What's up, everybody? This is attorney Dan Winnigan, and I want to talk a little bit about estate planning. And so I was doing some estate planning for one of my business clients, and this question came up where for some reason the homeowner was hesitant to use a living trust, but wanted the son to have the house if the father were to pass away. And so I got to know a little bit more about the situation, and um, the topic of transfer on death deeds came up. So transfer on death deeds are relatively new in California. They allow you to name a beneficiary of your real property by filing a transfer on death deed with the county. So very similar to your grant deed when you received your house. Now, these are good in very, very specific and kind of tight situations. They aren't good for all situations, and really not a really good long-term solution for estate planning. So let me step back a little bit and how, there's the probate process in California. And if you have assets over $150,000, you are subject to the kind of the more formal probate process. And obviously in California, real property and homes are worth a lot. And if you don't plan correctly, your home can be subject to the probate process, which the last time I calculated a market value, and this is not equity, this is market value of a home in California with a value of $500,000, which is pretty reasonable value. The probate fees are $11,000 alone. So it's a really good idea to get your planning in place so that your estate does not have to pay for the lengthy and costly process of probate. So what is going back to transferring of assets outside of the probate process. So there's the joint tenant process. So some people, what they like to do is add maybe their child as a joint tenant to the property, but there's a couple of reasons why you won't do that. One, you run into gift tax issues. Now the parents may have to file gift tax, which goes against their lifetime exclusion. Now, a home is in the child's name, and now if they do asset search, they're subject to potential judgments and lawsuits now because they have this real estate asset in their name. And so you don't want to do this without some proper education and proper planning. So those, a lot of people do add the kids to the title, which is not a really good solution, or even just transfer a title to the kids and then have the parents live in there. So transfer on death deed is kind of one stopgap solution for full estate planning. What that allows you to do is you get to name your beneficiary in the recorded form with the county. Now, there are some limitations. So if there's more than one beneficiary, you can only do equal amount across the board. So there's two beneficiaries, you can only do 50-50. You can't do 75-25. You can't do any of that. The other limitation, this is big, this doesn't account for predeceased beneficiaries. So if the children pass away before the parents, right, and the parents don't update this transfer of death deed, then the house could be subject to probate. So for these reasons, I don't like transfer on death deeds as a long-term solution for estate planning and passing down property to the clients, to the children or to the beneficiaries. But they are useful in some certain stopgap solutions while proper planning is in place. So the better solution for most people is using a revocable living trust. Now, again, using a revocable living trust can help you avoid the probate process. Like transfer on death deed as well, you can avoid Medi-Cal clawbacks. So a couple years ago, Medi-Cal does not look into assets that are held in that transfer outside of probate. So transfer on death deed and properties in revocable living trust avoid the probate process and can be are not part of the Medi-Cal look back process. But I think the biggest benefit of using a revocable living trust is that one is it's easy to amend, right? So if you have to amend the transfer of death, you have to file a new one, and then you got to file with the county, with the living trust. Just update the living trust to who you want the new beneficiaries to be and what percentage. Again, and then also you can determine what percentages you want each beneficiary to have with regards to that particular property. But I think one of the biggest benefits of using a revocable living trust in this particular scenario is that you can plan for predeceased beneficiaries. So if your children, for example, die before you, right, there's already a backup plan in place um, in case um, in case you have not selected a new beneficiary. And look, for some people, life gets in the way, they forget about it, and the planning, not on updating the estate plan, usually you're not on top of their list when a child passed away before the parent. And so, having a proper plan in place can ease that burden and have a smooth transition to the next generation. So, hey, this is Dan talking about estate planning for business owners, estate planning, and with regards to transferring real estate to the next generation or to the next beneficiary, and why transfer on death deeds can be good sometimes, but not always. All right, this is Dan. I'll talk to you soon. Bye.